There's two new people on the panel that you haven't heard from already. On the far left is Master Sandler. For those who are practicing in Toronto or practicing at all in the Master's office, you'll all know Master Sandler. Highly knowledgeable in the areas of civil procedure, highly impatient with those who don't know the areas, and takes great care in writing his decisions, and has been responsible for many very useful and informative decisions which are now forming part of our law. Many of them have been overturned and then reinstituted, and he has a lot of strong opinions in this area and will be a very useful member of the panel. On the far right is Claude Thomson, senior counsel with the firm of Campbell Godfrey in Toronto, one of the most senior members of the bar in Ontario and throughout Canada, very active in all the organizations of the Law Society and the Canadian Bar Association. And he too has some insight which he can bring to bear on the questions of the practical questions that can arise when litigation involves a foreign element. So perhaps we can start off right now by getting the panel moving by just turning to Claude Thomson now and have Claude consider the question or the considerations that he as a counsel would consider if a client came to him with a normal contract case or any other kind of case where he was considering suing someone in another jurisdiction.
All right. First thing that I do is to get in touch with a counsel from the alternative jurisdiction that I have in mind as being the possible situs of the cause of action. I would do that because, of course, it's very dangerous for us as lawyers in Ontario to attempt to pass an opinion ourselves on what we think the laws or practice of another jurisdiction may be. In my case, I'll probably phone a lawyer whom I might know from one of those other jurisdictions just to bounce some ideas off him in order to attempt to answer the following questions. First, if I win in the alternative jurisdictions I'm considering, how much money am I likely to get? Now, obviously, coming to mind the issue that was discussed in your panel this morning with respect to the sizable judgments that sometimes can be obtained in the United States in torts cases. But also you may have a look at different procedures, different rules of law in other jurisdictions which might make it attractive to bring the case elsewhere simply because of the amount of recovery. Secondly, an important consideration is the question of trial by jury. There are many jurisdictions in this world in which a jury trial is a constitutional right, as it is in many parts of the United States, and similarly in Great Britain and in Ireland. It's quite common that very complicated litigation be tried by a jury, and unusual that the jury notice be struck out, while of course in our jurisdiction, as you all know, the practice is somewhat to the contrary. Then I'm going to try to determine something about the cost. We have party and party costs here. Some other jurisdictions do, and we want to have a handle on that to see what significance that has in practical terms for our client. We're also going to have a look at the cost of the litigation and looking at things like contingency fees. How much is it going to cost my client to run the proceeding outside of Ontario? Also, I'm going to be concerned to have a look at the rules and procedures in the foreign jurisdiction. For instance, many of the states in the United States that have a record of giving such enormous awards also have a history of permitting defendants with deep pockets to exhaust a plaintiff financially by, for example, engaging on interminable depositions. A deposition procedure in many of the United States means that you're allowed to examine witnesses or potential witnesses before trial, and you can do that almost without end. And of course, to a plaintiff without much money, that kind of procedure can be financially exhausting. And then, of course, I'm going to look with special care at the procedural differences that may be involved within the various jurisdictions. For instance, I talked about deposition. From that extreme, which involves discovering everything about your opponent that ever happened, you get to the other extreme in litigation in Great Britain, where their discovery procedure is very rudimentary and very limited, as contrasted at least with what we're doing in Canada. And so you're going to be looking at all of that. Also, we might have a look and see if there are different Limitations Act, if there are different procedures within the rules of practice that are going to create delay. And of course, you're going to have a look at the general question of delay, because it's very much in your client's interest, if you're plaintiff, almost invariably, that you get the litigation on and get it over. And so one of the things you want to find out is how long are the trial lists piled up, and what kind of control, if any, does the court take over the process to ensure that you can't simply be stalled indefinitely. All right, then I'm going to ask a separate question. I'm going to say, where are the assets that this proposed defendant has? And with that, I'm going to be saying, does this defendant have a practical requirement to defend? Because, obviously, if the defendant doesn't have any assets in the jurisdiction that I'm considering as a jurisdiction of choice, and if the defendant is a company that can walk away from it, then I'm going to be very reluctant to bring the lawsuit and simply incur costs and delay for very little purpose in a jurisdiction in which I can't enforce my judgment. If, on the other hand, I decide that even though the defendant has no assets, for example, in Ontario, I may say that this is a company that's trading on the stock exchange someplace in the States, is a company of international repute, and I really don't believe that they're going to elect to ignore the proceeding. So I'm going to get on with it and see what happens. Because, of course, if they elect to defend, then they've adjourned to the jurisdiction. And again, in making my judgment, I'm going to try to pick a jurisdiction that's going to avoid interlocutory disputes, because that typically just plays into the hands of large companies or people with deep pockets. And I mean by that, if I have a feeling that there's going to be a big argument and lengthy proceedings over Ontario as being an appropriate forum, I may well, for that reason alone, elect to choose a different jurisdiction that really represents an area where my client's funds can be spent in prosecuting the lawsuit and preparing for trial, not in interlocutory proceedings that don't really advance the litigation. In general terms, I'm inclined to prefer to bring an action in Ontario for this reason. And we're talking now assuming that my client is a resident of Ontario. It's usually cheaper, more manageable, more understandable for the client to being able to rely on you here. And secondly, there's often a very considerable tactical advantage, because the foreign defendant that you'll often find involved in this kind of case is frequently distrustful. We think wrongly so, but frequently distrustful of the courts in a foreign country like Canada, and therefore are oftentimes uncomfortable and prepared to settle sometimes for more than they might if they really had a lot of comfort and confidence in the proceeding. And so I end up with the notion where I began. In making this kind of assessment, the first thing I think you should do is to talk on the phone to a lawyer who practices in the various alternative jurisdictions that are available to you, so that you can consult with 1, 2, or 3 lawyers if there are 2 or 3 jurisdictions involved, so that the advice you give your client will be thoughtful and ultimately work to his benefit.
Perhaps now we can turn to Tom Bastedo, and perhaps he can consider in the family law context whether there are different considerations when choosing the forum.
I think Claude has given a very exhaustive list, and I wish to add only 2 items. One of them is, let me give you a very brief situation. If the husband and the wife were living in Ontario, and the husband moves to British Columbia, and if the parties are over, say, 50 or 60 years of age, if the wife sues in Ontario, then the pension will not be a family asset. If the wife chooses to sue in British Columbia, by statute, the pension is a family asset. Therefore, it is necessary to look at the individual laws of the individual provinces in this country to determine whether it's advisable to sue in one jurisdiction or another. That's very important. Secondly, of great importance is enforceability. It is essential to obtain a result which, in family law, which even more, I think, than any other type of litigation, is one that it will be enforceable. Because a judgment for $5,000 a month, which is not enforceable, is not a judgment. Therefore, it is necessary to look at where the parties are going to be living and where the judgment can best be, where the pressure, if we can put it that way, can best be brought to bear on the person who's paying. As a subsidiary matter, that if there are children involved, it is essential to work out some sort of mechanism on enforceability as well, and it may be important as to the choice of jurisdiction in that regard. So those are the only two things I wish to add.
Okay, perhaps now we can turn to Master Sandler, and in this morning's discussion, there was a certain discussion with respect to compelling production of documents from American subsidiary or parent companies. Perhaps Master Sandler can deal with the question as to what the current state of the law is on the question of compelling the production of documents which are out of this jurisdiction.
You have to turn to the rules of practice, and there are two relevant rules, Rules 347, and connected to that is the General Discovery Rule, Rule 326, on the one hand, and then Rule 349 on the other. There is an obligation of a party to narrate relevant material facts on discovery and produce relevant documents. And the case law is that if you don't happen to know the particular bit of information that you're asked for, then you're obliged to go, if it's possible, to the sources that have it to tell you. So the vice president doesn't know what the service manager knows with respect to, or the design fellow with respect to the forensa, so he has to go to others in the company to make inquiries. And that has been in the law for very, very many years. The question was, how far outside of your own company were you obliged to go? What about former employees? What about subsidiary companies? What about subsidiary companies in other countries? What about parent companies? And all this was examined in a recent judgment of the case is called Gravlev versus Venture Tech, which I consider to be one of the most important and revolutionary cases in the last number of years on discovery. And they threw out the traditional tests and said both with respect to oral discovery and documents, the question was one of what is reasonable in the particular circumstances of that case. And therefore, it might well be possible to obtain oral and documentary production from foreign companies through the use of the Gravlev doctrine. That is to be distinguished from a situation where the document is in the possession of a witness outside the jurisdiction, and he isn't a member of the company that you're suing, nor was he a former member, nor is there any other connection that it would be found reasonable to require you to make the inquiries and attempt to obtain the documents. If that person were in Ontario, you could use Rule 349, which is documents in the power of a person, not a party. If that very same person is exjuris, query whether or not any such order could be made. The law is still in a little bit of a state of flux, and there are some current appeals from orders that I have made, and I really can't tell you ultimately where we are, but I say go back to the Gravlev versus Venture Tech judgment and start from there, and I think there is a great area for, on that decision, getting production of documents from corporations and individuals that are at least connected with the party that you're suing.
Just on that point, I brought with me an excerpt from the Canadian Tax Foundation writings, and there's a recent article that was written. It's a case comment on an American case, and it deals with the liability of Canadian companies to respond to U.S. summons for information. It's interesting to note that the American courts in this respect have differed from the Canadian courts in being very aggressive in compelling the production of documents from people in the United States. This was a case where the U.S. federal court was asked to compel the production of the Canadian Imperial Bank of Commerce at its New York branch of documents in the possession of the Canadian Imperial Bank of Commerce in the Bahamas. The bank resisted that subpoena on 2 grounds. Number one, that to do so would cause the bank to be in breach of Bahamian law, and therefore they shouldn't be compelled to do it. And secondly, that the U.S. courts should not exercise jurisdiction over the Bank of Commerce in relation to its activities or other affiliated companies in different countries. The way the U.S. court handled that was to go to the defendant in the prosecution and make an order compelling him to consent to the production of the documents. Then they turned to the Bank of Commerce and said, now that that's taken care of, we say that you, because you're carrying on business here in the United States, that gives us jurisdiction over you in your worldwide operations, so that we can tell you, because you're here and we can put you in jail or seize your assets, to do what we like. And that is, we can tell you to do it wherever you happen to be. They followed another case. This case is called the United States versus Quigg. They followed another decision, which is another Canadian bank case, Public Administration versus the Royal Bank, where in that case, the highest court of the state of New York determined that service of process in a civil case on the New York branch of the Royal Bank of Canada sufficed to give New York courts jurisdiction over an incorporated branch of the same bank located in France. Jurisdiction over the French subsidiary was obtained on the grounds that the subsidiary's existence and operations were indistinguishable from that of the Canadian parent, despite its separate incorporation. So it was a subsidiary of the Royal Bank operating in France. And the New York court exercised jurisdiction to compel the production or to gain jurisdiction over the operations in France because the Royal Bank was operating in New York. Now, these are perhaps somewhat esoteric, but it shows the extent to which other courts in other countries are moving, and we in Canada will probably be moving in that direction, I would think, in a year or two. And it just goes to show that taking an aggressive approach with respect to subsidiaries of foreign banks or subsidiaries of foreign companies may become effective, and there may be reliance placed upon American cases. This differs from the Canadian approach to date. There's a case called Frischke, F-R-I-S-C-H-K-E versus the Royal Bank, 17 OR 2nd at 388. I'll just comment very briefly on that. That was a case where in a major fraud case, they attempted to compel from the Royal Bank production of documents at the Royal Bank's branch in Panama. Initially, there was an order compelling the Royal Bank to produce those documents. That was overturned on appeal, and the Court of Appeal found that because that would put the Royal Bank into jeopardy of criminal prosecution in Panama, that they would not compel the bank, in this case the Royal Bank, to produce those documents. That was recently, it's just interesting to note when you talk about how these areas are developing. And one of the most recent Ontario reports was the decision of Senior Master Roger in Re McDonald and Bryant, and that's at 35 OR 2nd at page 161, where an issue arose as to where a person put in an affidavit, and then on cross-examination there was an application to compel that person to produce documents that were in Bahamas again. Senior Master Roger followed the decision of Royal Bank and Frischke and said that they would not compel the production of the documents in the Bahamas because that would jeopardize this privilege under Bahamian law. So the Canadian law, the Canadian cases haven't been as aggressive as the United States cases. I would think that in the future the Canadian courts will be more aggressive in that area. Do you have any comments on that, Bill?
No, I would, well, it's hard to know which way the Canadian courts are going to go. I certainly was familiar with that Frischke case, and it is completely distinguishable from the jurisdiction which the United States courts, as a rule, have exercised. The interesting thing, just coming back to my little hobby horse about, say, rules of public international law, if you want to try and wiggle them in there, they do occasionally play a useful role. You're trying to bolster a case. Might be like the Bill of Rights used to be in this jurisdiction when Mr. Justice Schrader used to say, oh yes, the Bill of Rights, you've come to the bottom of your argument, have you? And, maybe in public international law is sort of at that level, but you might be able to use it. It seems that at least as far as other courts are concerned, there is a distinction when a foreign court is exercising its in personam jurisdiction over a defendant which is present within its own jurisdiction to force that defendant to do something outside of its own jurisdiction, but in which it has subject matter and in personam jurisdiction over the individual defendant, as opposed to the situation where that court is seeking to exercise its process against a total foreigner. I mean, the Canadians, we complained in the Westinghouse case because what the United States courts were trying to do was to cause Rio Algom, which was a Canadian company with no presence in the United States, to produce documents in the U.S. courts. And Rio Algom was threatened with fines of $10,000 a day. Its president was threatened, et cetera, all this by the U.S. courts, although there was no presence in the United States whatsoever. And the Canadian position specifically was that was a violation of public international law and protested ambassadors' notes and all the rest of it. Whereas if there'd actually been a presence within the United States of Rio Algom having a subsidiary there or something else, everything starts to change. And the United States courts will then say the parent company is present in the jurisdiction by virtue of the presence of its sub. They serve their documentation on the subsidiary, et cetera, and there's that jurisdictional handle which tends to change the thing. And I think a lot of these cases have to be looked at in that respect. And along the lines of that Royal Bank case, on that page 14, actually, of my memo, I speak of some of those American cases along the same lines.
Perhaps now we can turn to what's probably the corollary of the first question that we asked Claude Thomson to deal with, and perhaps we can throw it back to him again. And that is the considerations that counsel should consider in determining whether to defend an action or not that's brought in a foreign jurisdiction, or perhaps to advise someone who is being brought into Ontario whether to defend it or not. Perhaps, Claude, you can consider some of those questions.
All right. Again, I start with the first and most important question is you determine from your client whether or not it or he or she has assets in Ontario or has any commercial reason or other reason whereby it must defend. Because if the practical answer is that it's going to have to defend because it can't afford to let a default judgment go, then that's the end of that. Now, if on the other hand it's a realistic possibility to allow the default judgment to go and leave it at that, then you're going to have to decide whether or not you're willing to risk bringing a motion to set aside the service, or whether you're going to risk attempting to file a conditional appearance, etc. I'm not going to get into the cases on it, but obviously to the extent that you advise your client to get involved in the Canadian process, then to that extent do you run the risk that a foreign court may decide that you've really adorned to the jurisdiction. And of course, that's not a question you should be answering yourself. You should be answering that question taking advice of counsel in another country. I want to raise a subsidiary question to this that also flows out of what Bill Graham was just talking about. I think more and more we're going to have interesting kind of tugs of war between various jurisdictions. I had two that you might find interesting that I thought to be a remarkable struggle between the jurisdictions of an American state and the courts in the province of Ontario. One was an instance in which I acted for a company in the Hammond and McIntyre case that I think is referred to in Bill's material. That was a case in which an employee of my client sold shares in Canada. The circumstances in which that sale would have been unlawful against one of the regulations of the Securities and Exchange Commission if the sale had occurred in the United States. I didn't think that the sale was unlawful at all. However, a shareholder in the United States started one of these class actions alleging that it was. And a United States judge insisted that my client in the United States commence action against its employee and get a judgment because the employee refused to defend in the United States for the unlawful trading in the company's shares. Then the United States judge insisted that my client sue in Canada in an effort to enforce that judgment, notwithstanding the opinion that he had from me that the action wasn't going to be successful. And indeed, the action had to go to trial. And the risk was that if we hadn't gone through those links, the view that we had from the American attorneys involved was that the judge would have been prepared to grant judgment on the class action against my client, in effect for corporate waste, for the amount that was at issue within the proceeding. And then the second example is a case in which I attempted to have an action state. An action for virtually the same relief was started in a court in Chicago and was started in a court in Ontario. My client was defendant in Ontario and plaintiff in Chicago, and really wanted the litigation determined in Chicago. And both clients had connections with the state of Illinois. I moved, according to the rules that somebody was talking about here this morning, and lost. And that was it, and I decided, well, I guess I'm going to have to defend the action. The Ontario judge said that the jurisdiction here was not inappropriate, and it wasn't demonstrated by me that the forum convenience rule applied. But what happened was that the American attorneys for my client, that having happened, persuaded a judge in Chicago to grant an injunction restraining the other side from proceeding with the litigation in Ontario, and threatened them with jail if they didn't instruct their counsel to discontinue the Ontario litigation. So that was how I won that case.
Now, perhaps Master Sandler can deal with a recent case that's come out that has some significance in this area.
On the question of choice, and we get very close to home, Ontario and Quebec. And there's a motor vehicle accident in Quebec, and the plaintiffs reside in Ontario. And in this case, the citation of which I'll give you in a moment, the court found that the accident occurred in Quebec, the defendant lived in Quebec, the plaintiffs resided in Ontario. The suit was brought in Ontario. The court found that the defendant was negligent by traveling at an excessive speed and breaching 2 provisions of the Quebec Highway Traffic Act, and that this was the sole cause of the accident. The court then assessed the damages, and Quebec's Automobile Insurance Act deprives persons in the plaintiff's position of a cause of action in Quebec in return for a statutory scheme of accident benefits, and the issue arose as to whether the provision of the legislation in Quebec constituted a defense to the negligent action brought in Ontario. And it was held that the plaintiffs had a valid cause of action, and that provision in Quebec law, which would have prevented the plaintiffs from recovering, did not apply. So the choice was very significant. If the plaintiffs had sued in Quebec, they would have been unsuccessful because of the statutory scheme for compensation based on a schedule in a statute similar to the British Columbia system. They sued on Ontario and they were successful, and presumably they could easily recover since the insurer carried on business in both jurisdictions, and under our statute, if you get a recovery against the insured and he is insured by an insurance company, you can then sue the insurance company. So this case, which is cited at 35 OR 2nd 201, decision of Henry J. SCO, Going, G-O-I-N-G versus Reed Brothers, demonstrates how important it is to make the right choice.
But in that case, did the court in Ontario find that the laws of Ontario would apply to the accident?
Yes.
Well, perhaps, though, that the court must have said that the procedural scheme that was referred to is in the nature of something that's procedural, like a statute of limitations. Because while it's always been said, as Bill just observed, that the law that governs the tort is the law of the jurisdiction in which the tort happens, and nevertheless, that deals with probably things like rights of way and the question of was there negligence or not. But I would think that the procedural scheme could be analogous to a statute of limitations, which does not have any extraterritorial effect, and so that perhaps the case can be explained on that basis. But if it's purporting to say that the law of Ontario is the law that governs the determination of the question of whether there's a tort, and that certainly is contrary to any principle that I know of.
Well, all I can say is that, one has to, it's a very long case. I just saw it this morning, and one should study it, but it does show and highlight the importance of the proper choice of where to commence the action.
Now, Master Sandler, you have been involved in a number of the cases involving currency conversion, and it's a complicated area, and perhaps you can is there any way to summarize what your views are on where the law is going to be in a year's time?
Well, I need help from my colleague Bill Graham on this.
Self-fulfilling prophecy.
That's right. I think in a nutshell, you must distinguish between form and substance. One of the confusing elements is that people are looking at cases dealing with form, i.e. striking out special endorsements, and trying to derive from those cases what the substantive law is on what date will be chosen to make a currency conversion. And as I've tried to point out in the Air Temp and Chrysler case, and I was somewhat misconstrued by the divisional court, you don't...
It's a euphemism for being overruled, isn't it?
No, I wasn't. I wasn't overruled. In fact, I wasn't. They agreed with me all the way along, as a matter of fact. No, the point is that as a matter of form in a special endorsement, because you have to tell the defendant what your claim is with full particulars, then you have to set out the claim in Canadian currency for that reason, and also because of the the Currency Act, which requires legal documents to be stated in Canadian currency. And you have to tell the defendant how much money, as of the date of the writ or as of the date of service of the writ, will be necessary to stop the action. And you also have to set out in your writ what you're contending for. Therefore, when it comes to the striking out of the special endorsement or the form of the special endorsement, as long as you give complete particulars of what your claim is all about and how it's calculated and what position you are choosing with respect to currency conversion, there is no obligation to make it any specific date. If it's more advantageous for you to choose breach date, and that's what you want to go to trial on, say so. And if, in fact, you want to choose payment date, since the writ is asking for payment at that time, then you choose writ date. It does not mean that if you choose writ date as of the date of the writ, you will be prevented from asserting judgment date, which could be 4 years down the road, if in fact you get over the hurdle of writ and get over the hurdle of motion for judgment and you go along to trial. The substance issue is, what's the right date? And on that question, the most important case, as Bill Graham pointed out, is the Batavia case of Mr. Justice Carruthers. And he and I think, agree that all that case did was adopt what was said by the House of Lords in Miliangos and looked at the category of debt called judgment debt and said, with respect to that category, in the peculiar circumstances of this case, judgment date, that is, local judgment date, is the date for conversion. And Miliangos and the House of Lords left open what the conversion date might be, or what would be the appropriate conversion date in other kinds of debts, invoice debts, judgment, at least damages and other claims which were not reduced to judgment in the foreign in a foreign jurisdiction. That's the substantive issue, and I don't think it's settled by any means for all kinds of claims. I think I held in Bedford and Shaw, I haven't read it recently, it's in the material, I think I held that with respect to judgment debts, foreign judgment debts, that the Batavia case adopted the principle that for all of them, the date of conversion is the date of the local judgment here. And Bill Graham says that may not be right. It even may depend on the facts of each case with respect to that category of foreign debt. And I think we may disagree on that one point. Bill?
Well, perhaps my point in respect of that was, I think you can read Batavia as saying that in His Lordship's view, in that case, equity required that the conversion date be the date of his judgment. Because, as he pointed out, since the date of the foreign judgment on which was being sued on in Ontario, the Canadian dollar had gone up, that is to say, and therefore the currency of the foreign judgment had gone down. Yes, everyone looks a little shocked, but that was previous times. In any event, that is what happened. in the facts of that case. But I put it to you that when you read Millie Angus, when you look at the other cases where one is speaking of trying to achieve equity between the parties, that if in Batavia what had happened was that the Canadian dollar had gone down, that the judge wouldn't have then said, well, I'm now going to give you a lesser amount by virtue of giving you the amount, the conversion date as of my local judgment. I think if you read his reasonings, I think you would come to the conclusion he would have said equitably, you're entitled to the higher amount because you got that judgment in Swiss francs 2 years ago when a Swiss franc was worth more, and you're entitled to have that because there's been a delay. Now, of course, I realize all I'm doing is introducing a confusing factor because now we're saying what, equity is the length of the chancellor's foot. And if you want to check that, you can look at a Quebec judgment or Sini and Scott, which goes exactly the opposite way from the Batavia times. In the Quebec courts, they took the position that, that it was not equitable to require a judgment debtor to suffer the difference, the depreciation of the currency in the difference of time. And in the view of the Quebec courts, it should be the judgment creditor who suffers that because, after all, he got his judgment and he should move on it quickly. And why should the judgment debtor be the one to suffer? So I suppose you could say that those two cases stand for the proposition that Ontario favors judgment creditors and Quebec favors judgment debtors, and perhaps that says something about the difference between the two legal systems.
There's one other point that I wanted to raise, and it wasn't brought out in the Sheila Block paper or the lecture, and it does relate to the strategy and what you do if you want to commence an action against someone out of the jurisdiction. There's a recent case, two recent cases, dealing with the question, and that is, if part of your claim falls within Rule 25, but you want to assert a claim in respect of an injunction or a declaration or some other equitable relief that does not fall within Rule 25, can you serve ex juris? And in the decision of Tridon, T-R-I-D-O-N versus Otto, O-T-T-O, second word B-I-H-L-E-R, 21 OR 2nd 569, which was recently followed in another case called Guzenko and Martin, 34 OR 2nd 394 of Master Roger. When looking at Rule 25 on page 67, Rule 25 says that you can serve ex juris in relation to those matters. It says in Rule 25, where the action or proceeding as against the party consists of a claim or claims, and it sets out that heading. That was interpreted by Master Roger, and in the earlier decision, where it says Rule 25 consists of means includes only. So that you can only issue a writ and serve ex juris where your claim includes only the items, one or more of the items set out in Rule 25. Now that could pose a strategic problem in certain cases where you may want an injunction or any other kind of relief that doesn't fall within that provision. I think that's still the law.
Yeah, it is.
Now, one point I'd like to raise with Tom Bastedo that I had certain questions about, and that is I had a case where a client fell in love with a girl from Texas who obviously liked a lot of money, and he had a lot of money. He had a development in Arizona. He lived in Toronto and had property in Toronto. There was no way he could go into that marriage without a marriage agreement. The question then arose, what good is an Ontario marriage agreement or pre-marriage agreement if he's got property possibly in Texas, possibly in Arizona, and possibly wherever else they may happen to be throughout the world? How does that guy protect himself?
He doesn't get married.
Well, I told him that already.
That's a very difficult question. With respect to the specific facts here, I happen to know something about Texas and Arizona law, so I can answer this particular question. But if we had taken another state, for instance, I know that in Arizona and Texas, they're basically descendants of the Spanish community of property system, and contracts there are easily accepted. If we take another state, such as Illinois, where marriage contracts are not easily accepted, then it may not be possible for him to protect himself so well. My first advice, therefore, would be to check on the jurisdictions and where the property is situate if it's immovable property, then the property can't be moved. And you've got to deal specifically with the property which is immovable by specific provisions in the contract. Secondly, if he's really worried about it, he can transfer funds in advance to his wife. This is one effective way of preventing difficulty, in effect make a settlement on marriage, and that in effect resolves things in advance. Now that has its risks as well, but that's one other solution. The third other solution is to put the property offshore, and if he really has this much money, he can probably hide it somewhere. I don't really have any other
No, but the question...
any really...
No, but the basic question is, could you include in a contract like that, a pre-marriage contract like that, a provision that says, this contract shall apply to movable property wherever it's situated, anywhere in the world?
Well, yes, you can, John, but in Ontario and in Canada, as I tried to point out earlier in my lecture, the trend is to avoid those contracts unless they specifically anticipate specific property. And I think that in the cases now, there's a clear indication that if the contracts specifically anticipate property, then they will be upheld.
If it refers to specific property?
Yeah, let's say there's an apartment building in Vancouver, and the contract specifically deals with that apartment building in Vancouver, then in my view, they're clearly caught under the relevant statutes in this country.
One other question I had arising out of your material, and that was, it struck me when reading your paper that the recovery for a wife or a husband could be affected by the place where that person moved to after the separation. So that if a wife and husband and wife were living in British Columbia and they separated, and the wife went to a smart lawyer and she said, I'm leaving the bum, and he said, well, whatever you do, don't go to Ontario, go to Manitoba, you'll get twice as much. Is that the state of the law now in Canada?
Yes, it is, and this is not widely recognized. For instance, let's take a fairly simple situation. If there is a 30-year marriage, let's say there's $3 million that the husband has amassed. In Ontario, that woman will probably get somewhere around $300,000 to $400,000 or $500,000. In British Columbia, it's virtually certain now that she will get half of the $3 million. And there's that there's that wide a range, and this is not generally recognized. The other point, which we haven't talked about, is that if the husband moves to specific jurisdictions, it's virtually impossible to bring enforcement proceedings, and it's easier to enforce a judgment from Ontario in New South Wales than it is in Michigan, or Michigan's a bad example, Illinois. And you have to be acutely aware of the enforceability of judgments in all of the various jurisdictions.
Or alternatively, a husband who wanted to defeat a wife's claim could move to a different jurisdiction.
Illinois is the best one, yeah.
That's the best piece of information you're going to get today.
Illinois, or Texas, I hear from Ron Slaght, isn't a bad place to be a judgment debtor either. Apparently they have statutory protection there that virtually prevents anyone from any other jurisdiction from coming into Texas and enforcing judgments, so that you've got a whole population of deadbeats all through Texas driving Cadillacs and protected by the state laws. Now, are there any questions that anyone's got? Maybe we can open it up a little bit now. I think we pretty well exhausted the panel.
Perhaps we've exhausted the audience too, John.
It's awfully hot. Does anybody have any questions? All right, then I guess that's it. I'd like to thank all the... I'd like to thank all the panelists for staying around all day, and thank all of you for staying around.